We continue reading the case of Fiona Alfred versus Mario Alfred, divorce case that was heard between 2021 and 2022. And remember to also read the linked documents and file in the description of this video below, and to subscribe to the channel. Thanks in advance for subscribing. Now we look at submissions for the defendant, and as you see, this is a bitter divorce case, but it gives some lessons for you as a married person or someone who has been in a common law relationship for 5 years or more. And it doesn't matter how long you've been married. Remember, these people were married for 17 years before they separated and lived in the same house. And then 2 years later, one moved out and lived in a different house. Right? Now, for the defendant, Mr. Alfred, Mr. Anthony Williams, counsel for the defendant, that's Mr. Alfred's lawyer, argued that the Property Rights of Spouses Act is irrelevant as the LAA, that's the Liability for Actions Act, I believe, supersedes it. The name of this act slips me. Right? He submitted that the main issue was whether the legal title of Mrs. Alfred, of the claimant, had been extinguished by virtue of the provisions of Section 3 and 30 of the LAA. Counsel stated that the court would have to consider the following sub-issues. A. Whether Mrs. Alfred abandoned the property from July 2007 to December 2019. B. Whether Mrs. Alfred or whether Mr. Alfred had factual possession and the intention to take possession of the property from July 2007 to December 2019. C. Whether there was an agreement between the parties that Mrs. Alfred would take care of the family expenses in the USA, while Mr. Alfred would take care of the expenses in Jamaica, as alleged by Mrs. Alfred. And D. What are the consequences when a joint proprietor of a paper title is deemed to have abandoned the subject property? Counsel asserted that there was clearly factual possession on the part of Mr. Alfred, that he clearly possessed the property, who also intended to assume full ownership in his own name and exclude Mrs. Alfred as title owner. So basically, Mr. Alfred bought the property, Mrs. Alfred migrated, and for 12 years she lived overseas, and according to Mr. Alfred, abandoned the property for 12 years, so should not get a share in it. He submitted that this was obvious, as Mr. Alfred single-handedly paid the mortgage, the taxes and maintenance, and had the sole responsibility of renting, changing locks, and converting the premises for his business. Counsel further submitted that there was no agreement about paying expenses because Mr. Alfred financed both the US and the Jamaica debt, and nothing was shown by Mrs. Alfred to disclose expenditure incurred or how she financed them. He added that it was significant that Mrs. Alfred was never cross-examined about her assertion that she never seen. Oh, Mrs. Holden Alfred is Mr. Alfred's mother, it seems. That she had never seen her daughter-in-law, the claimant, at the property after the funeral in 2007. Okay, so what I said earlier was not really a typo. It was Mr. Alfred's mother, whose name is Holden Alfred. So she was brought there as a witness. Mr. Williams urged the court not to interpret the fact of the defendant, of Mr. Alfred, obtaining the replacement title with Mrs. Alfred's name thereon as an indication that she was not dispossessed of the property. He argued that this should not be seen as the slightest action taken by Mrs. Alfred because Mr. Alfred initiated the process. He added that Mrs. Alfred could only have asserted that she was not dispossessed or discontinued, that she did not discontinue possession if she had personally generated the discussion or taken steps to replace the title. Counsel argued that Mr. Alfred was never an agent for Mrs. Alfred. He stated that there was no discussion on that subject for any such agreement between the parties. Additionally, counsel highlighted that the February 2020 email message was irrelevant because Mrs. Alfred's rights have already been extinguished by that time. Mrs. Alfred's rights had already been extinguished by that time. And Mr. Alfred was just talking about what was on the title. Okay. He also asserted that the court should look at the circumstances of the email which spoke to the sale of the property and the claimant, that's Mrs. Alfred, owing a 50% interest, and find that it was not an admission of her rights to the property as the defendant was not accounting to her. Counsel reasoned that Mr. Alfred was simply returning to Jamaica and wanted to inform Mrs. Alfred about the loan owed to his mother and the financial outgoings of the property. Counsel relied on, and these were the various cases that Mr. Alfred's lawyer relied to make some of his decisions. The issues, we'll look at the issues in a different video.